Welcome to the WN Legal Podcast.
Welcome to WN Legal's podcast. My name is Q. Before we proceed today, I just want to say that whatever I say today is not meant to be legal advice specifically for your case or your scenario. Podcast is purely a discussion in respect to informing the public of what to do when you're facing with certain circumstances. Today's discussion in our podcast will be on assisting self-represented litigants, specifically in criminal matters. So what happens is when you're charged by the police, when you have been investigated, when you have done a video record of interview, or where they've been to your house or arrested you, what do you do from there? This podcast may be a bit lengthy because from step 1 to Z, the very last step can include from being arrested from the beginning until at the very end, either you're being sentenced because you plead guilty, or you've been convicted and you plead and you're being sentenced, or you're acquitted. That's where you win. So I'm just going to start from the beginning. How do you know you're being investigated or facing a certain set of circumstances? Usually it came out of perhaps what happened the night before or the month before. Sometimes there are matters. I had a matter where the charge came about 40 years after. That's in relation to a child sex offense. But usually it's within the first 2 weeks to first month, you would get a call, or the police will attend to your premises or your workplace. In fact, that depends on how serious your case is. If it was a simple assault, usually they'll leave a name card by your doorstep. But if it's to do with perhaps drugs of marketable quantity, they would usually arrest you in your premises, and they would invoke what we call Section 24 of the Misuse of Drugs Act. So they would actually go into your premises and they would search your whole house and gather evidence. Sometimes you just don't have a choice because a Misuse of Drugs Act search warrant is one that can't be refuted, if I can put it that way. You would just have to let them search the premises. They would usually have a video on, and they would be going through your stuff, and they will be asking you, is this yours, is this yours, and is this yours? Whenever they ask you all these questions, any admissions you make will be used against you, because that video will be used in court, and the magistrate or the judge or the panel of juries will be looking at them. So if you're in those set of circumstances, you're in a bit of a pickle, because if you say no comment, they can draw, according to the law, they can't draw negative inferences, but at the end of the day, the video is there to capture where the item is. Moving away from that part, that's just the beginning. You would then be either served with a statement of material facts and a prosecution notice, or you would have to you receive summons, court hearing notice, or you would receive bail. These are all preliminary documents that would get you to court. In criminal matters, the first point of reference is usually the magistrate's court. Even if your matter is indictable, which is serious, or summary, less serious, they all start in the Perth Magistrates Court or in any magistrates court closer to your suburb. So if you're in Joondalup, then it's Joondalup Magistrates Court. If you're in Osborne Park, for example, you're usually in Joondalup Magistrates Court. But if you're somewhere in Dinella, you would appear perhaps in the Perth Magistrates Court. Then there comes your first court appearance. You would, before you do so, you should seek legal advice, because when you go to court, at the end of the day, they're going to decide whether you're guilty or not guilty, or whether your charge can be discontinued. So all those things, all these issues would need to be ventilated before your first court appearance. That's probably the best way to move forward. Look at what you have received and look at the facts. And those facts in the statement of material facts, they are what the police have decided upon as the facts of your case. And they would then decide to prosecute accordingly. The investigating officer would then gather materials, such as statements. If it's to do with child sex offenses, they would gather all computers, your laptops. They would try and see which service provider you're using, and they try and contact them and do what they have to do from there. A lot of the times for illegal transactions or illegal web search There are websites such as Tor, Tor, that would have been utilized, and not all of them are trackable, but they would look at your email address, they would look at your hard drive, and things along the likes. I've digressed because what I was trying to say is that when the police investigate, they would go into all these nitty-gritty things, but they would all look. The point of reference would be on the statement of material facts. They would gather DNA evidence if they need to, statements of all these people, but you don't actually get to see them. That's the disadvantage. The Criminal Procedure Act, when you go to court, dictates that there are ways in which you can then obtain your evidence that's against you, or ways that if you don't do that, then you have to decide what you want to do, whether you want to plead guilty or not. It's very important that you look at these facts, that in the documents that are provided to you. You would usually be provided with your video records of interview as well, because those are confessional materials in the Criminal Procedure Act, and you're entitled to receive a copy of it. Before your first court appearance, you should receive legal advice, because when you do see us, we would advise you on what defenses you would have. In the Criminal Code Compilations Act 1913, Chapter 2 of it have a myriad series of defenses that you can use, depending on what charges you have. For example, if you have an assault charge, which is the bread and butter of WN Legal, I do about, every month, I would do about 3 to 4 trials for assault, but that's just an estimate. I do a lot of restraining orders, a lot of drug charges, but every one of them is different. I'm just going to give you an example for assault. The defenses under Chapter 2 of the Criminal Code, I urge that you look it up, includes self-defense, provocation. Sometimes people would use unwilled act, intoxication, insanity. But let it be known, not all these defenses are feasible, because provocation is only a partial defense. Unwilled act is so specific, and the case laws backing up the argument of unwilled act is so specific that it may not be applicable to your case. And insanity is probably not available. That's usually for murder. Self-defense and provocation are the main one. A lot of the times when my clients or prospective clients come to my office, they go, "Hey, Q, I punched someone, but that guy provoked me. He pushed me first." Well, I would sit them down, and the whole first initial consultation with them is to discuss what Chapter 2 self-defenses are, self-defense and provocation, and how do they affect the case, because it's not as simple as he's pushed me, he said something bad to me. For example, provocation, according to the Act, you need to have lost your passion to cool because of an act of insult or assault. So if someone has to push you nonstop and really push your buttons to the point where the court can be persuaded that indeed you were provoked, you lost your passion to cool. When I say passion to cool for provocation, for instance, it's not, oh, you've been in the room for 5 minutes, then you go out there and you punch someone. It has to be almost instantaneous. That's the definition of provocation. Again, I digress, but the whole point of this conversation here in this podcast is to tell you that there are defenses out there. If they are not in Chapter 2, there are defenses of self-defense, and sometimes the factual matrix of your case is just not tenable to be prosecuted. I have several instances where the trial lasted for an hour because the facts just weren't tenable. They could not be prosecuted on those set of facts. It's best that you speak to us before you decide to go in there and enter a plea of guilty or not guilty. But for self-represented litigants, that's your immediate ultimatum, is to decide what you wish to do with the charges. When your first few court appearances, when you go before a magistrate, they're very kind magistrates. They would afford you a lot of opportunity to seek legal advice. A lot of people choose not to because they believe in those set of circumstances they are guilty. Or in those set of circumstances, they're definitely not guilty. Again, what the public perceive the case to be and what lawyers perceive the case to be are completely two different things. We follow a certain set of procedures that are there because of the code and various other acts such as the Criminal Procedure Act, Criminal Investigations Act. If it's drugs, that would be Misuse of Drugs Act, Poisons Act, and things along the likes. There are so many acts out there. It's best that you don't just go out and Google, because Commonwealth Acts and WA Acts, state acts, are two different things. So during these court appearances, you have to decide what you need to do and speak to us, perhaps, and then we can decide and provide you with advice on a preliminary basis of what you wish to do. If your matter is summary, which is not a crime, if you look at the charge they're faced with, go Google, best friend, Google, just go Google the charge and Google the specific section, so 313, or for example, and just go Google it. And if it says if the person commits a crime, it's indictable. If it says commits an offense, then it's summary. That's in the magistrate court. Now, if it says it's an offense, you can actually plead not guilty and ask for disclosure. But if you plead not guilty, I'm going to put a caveat here during this podcast. If you plead not guilty, you're going to lose a certain percent of your discount in sentence. So the same applies for indictable offenses. But the procedure for summary and indictable is completely different. In summary offenses, you need to plead not guilty in order to get disclosure materials, as I've referred to earlier, such as statements or any DNA materials, forensic materials, anything that they have that they believe they can prove beyond reasonable doubt that you have committed a certain set of circumstances, a certain set of offense. But in indictable matters, those matters progress from the magistrate's court to the district court, and sometimes magistrate's court straight to the Supreme Court. Murder, for example, life imprisonment, anything to do with life imprisonment. Sterling Gardens is a specific magistrate's court in the Supreme Court that deals with high-end offenses. Arson and murder are definitely there. Arson is burning down a building with intent, for example. But then I digressed. Again, in the indictable offenses, you first need to decide what you want to do. But instead of pleading guilty and not guilty, there's actually another path. It's the middle path. It's called to proceed to a committal mention hearing. That's in the district court. Proceed to committal mention hearing in the magistrate's court for district court matters, and ask them for disclosure without entering any pleas. So you don't enter your pleas, you lose thus a discount in your sentence, and then you see what they have. This is not an easy process, because they would give you briefs and briefs and briefs of just documents, statements. A lot of telephone intercepts come through from there. DNA forensic materials. Sometimes they engage crash test experts and things along the likes. So during this period, you receive all these documents. You should engage a counsel, because we would then tell you what the defenses are and whether the prosecution can prove beyond reasonable doubt based on those set of circumstances. The next podcast I'll be talking about will be trial, but I'm not going to be talking about them right now. But basically, in this podcast, it would be advising what self-represented litigants need to do from the beginning, looking at the facts, deciding looking at what law is applicable, what defenses you have, and then the process and procedure going through court. It all starts in the magistrate's court. Then you proceed further from there. There are some procedural court appearances. Sometimes you want to do a bail. Sometimes there's a schedule to offender. Sometimes there needs to be a variation of your bail or negotiation with the facts of the prosecution. Sometimes you can choose to have a downgraded charge. For example, unlawful wounding, if you didn't break the skin, it's assault occasioning bodily harm. And for example, assault occasioning bodily harm, if bodily harm is not proven, then it's just assault. There are many cases where there are ways of negotiating, and sometimes you can even negotiate for discontinuance if you believe the defense is so strong that they don't have a tenable case against you. But I recommend that you don't do that until you speak to your lawyer, because you're showing your cards. If you do show your cards, they know where you're going. They're going to investigate further, and they're going to find further evidence. These are things that you need to consider. There are a few stages of silence where an accused could choose to elect to use. So you have to consider them very wisely. Video records of interview, no comments, or to not say anything. Or during trial, whether you reserve your right to give evidence. It's entirely up to the self-represented litigant or the accused to make that decision. The decision will be made solely upon, in my opinion, when I prove my clients, whether they are credible, reliable, whether they can withstand cross-examination. Not many people can. Cross-examination is designed to actually catch people out. I'm going to be talking in my next podcast about Section 21 of the Evidence Act, but that's a story for another time. I will conclude this podcast because I've explained the beginning steps, at least for self-represented litigants, of how they should move forward if they don't have the resources to engage in a counsel. But even if they don't, I still recommend that they attend for a meeting, because sometimes you just can't help it. Self-represented litigants can't go all the way without being represented. The facts and the law, they're completely different. It's not quite a DIY scenario when you're in court. There will be a magistrate or a judge. There'll be opposing counsel. And all we're dealing with is your facts and the rules of evidence and deciding whether you're guilty or not guilty. Don't do it by yourself. That's my recommendation in all instances, unless it's a simple charge. Excess 0.08. Sometimes you can go in by yourself, but I would recommend not. And I would recommend that you speak to a lawyer before deciding whether you should go in by yourself. Thank you for listening. Till the next time.